It says, I signed a lease agreement on April 19th to begin on May 1st. Now, this is from a tenant. The landlord called and stated that the property will not be ready until May 7th. It's now May 17th and it's still not ready, and the landlord continues to claim that they cannot receive the materials. I asked to be released from the lease agreement, and the landlord said that I would forfeit my security deposit in rent. What can I do? Well, for reference sake here, you can go to Nebraska Revised Statute 76-1426, which is a part of the Nebraska Landlord Tenant Act that deals with failure to deliver possession. And first of all, if the landlord is listening, do the right thing and refund the security deposit in the lease agreement. However, if you're the tenant, immediately issue your landlord, and it doesn't have to be in any kind of fancy format. Just make sure you identify the names of yourself and the landlord, the property address, and then title it 5-day notice of failure to deliver possession. That is going to be the subject line on your notice. Under 76-1426, the tenant is allowed to serve the landlord a 5-day notice of failure to deliver possession. If at the end of that 5-day notice period that they still haven't delivered notice, then the tenant can legally terminate the contract, and under the statute, the landlord is required to refund all prepaid rents and all security deposits, including pet deposits, 100%. And if they don't do that and the tenant sues, there's punitive damages available. If they can receive up to 3 times the monthly rent or 3 times actual damages, whichever is greater, plus attorney's fees. And the tenant damages could be substantial because maybe they had to go out and get a new apartment at a higher cost. Maybe they have storage costs because of their household goods, because they maybe had to move out of their previous rental unit. Maybe they're living in a hotel. So their damages could actually be pretty substantial. Now, landlords, here's what you cannot do. In this case, there is the sink and some plumbing and whatnot that isn't done. It's not operable. The landlord can't just say, you know what, then fine, I'll give you your deliver possession to you, and then when these parts come in, I'll come in and fix it. That's not how it works. This tenant and every tenant is entitled to get their, they were assuming they were going to get a fully functional rental dwelling, which included, all the amenities in the kitchen. They didn't get that. That's important. Had the landlord known that they weren't going to have those parts, and in writing, the landlord and the tenant agreed that the tenant would still move into the property and take it the way it is, and then the landlord would effect the repairs after the fact. If they'd agreed to that previously in writing, that's a different story, but that's not what happened here. The tenant presumed that they were going to get a 100% fully functioning rental unit at the time of move-in, and they don't have it. So landlords, this landlord just can't say, fine then, if that's the way you want it, you can move in and then I'll fix the items later. That's not what the law says. That's not what this tenant is entitled to. So in my opinion, if you're the landlord and you're listening, do the right thing, release them from the contract, give back any monies, and when it's ready, rent it to somebody else. And if you're the tenant, in writing, written notice, 5 days. Now don't forget, this is how it works. The day that you hand deliver it or the day that you drop it in the mail first class, that is the surface day. That doesn't count. The next day is the first of the 5 days. On the 6th day, you terminate the lease. You terminate the lease agreement based on the 5-day notice and demand your money back. And that's how you take care of this situation.